And then we tried to have consensual sex. That didn't work over this apartment because he couldn't perform.
We're in Olympia, Washington for a hearing. 56-year-old J.D. Messner and 65-year-old Julie Davidson have applied for anti-harassment orders against each other. 2 months earlier, Messner, who manages the Whispering Woods mobile home park, got into an altercation with Davidson, who lives on the property. Messner says Davidson threw some items at him and grabbed his body camera, which he's required to wear for work. Davidson admits she knocked some stuff off of Messner's desk, but denies touching him. Today, both parties appear without attorneys before Court Commissioner Paul Wall because Messner's previous protection order issued against Davidson is about to expire.
All right, Mr. Messner, I'm going to let you go first. As the original petitioner. And then after that, Ms. Davidson, I'll hear from you. Okay, Mr. Messner.
Okay, Ms. Davidson had come into my office to talk about the inspection that I did about 2 months ago now. I had a body camera that my management company requires me to wear when I'm out on the property. I reached over and turned it on, and when I did, she snapped and went ballistic. And she made the threat. She goes, "Remember, I have a gun and I know how to use it."
Your Honor, I don't have a gun to my name. My children stole all my guns. They're gone. The only thing I have is pepper spray. I've lived at the Whispering Woods trailer park for about 15, 16 months. J.D. Messner and I became instant friends. The next thing I know, we're going out to dinner. That's how well we hit it off. And then we tried to have consensual sex. That didn't work over this apartment because, well, never mind. He couldn't perform. But I really liked him, and I want to apologize to you personally. I just want you and I to get along and work together. But your nuts are tied for management.
Now, Ms. Davidson, let's take a breath.
I'm
here.
sorry. I'm sorry.
Everybody take a breath.
I just want things to work out.
Now, it sounds to me like you don't really want an order against Mr. Messner.
I don't.
Okay.
And I don't think I deserve one against me either. We have to live 50 feet across from each other.
It sounds to me like Ms. Davidson doesn't want that order she applied for, so I'll just allow her to withdraw that.
Okay, Your Honor.
Thank you.
After Davidson's order is withdrawn, the commissioner moves on to Messner's request.
This comes down to whether Mr. Messner has proved to me by a preponderance of the evidence that there's been this course of conduct done by you, Ms. Davidson. I'm concerned that there's a lack of proof. The evidence is not strong enough on that. So, Ms. Davidson, what that means is I'm not going to issue an order against you as Mr. Messner requested.
Thank you.
And with that, the hearing comes to an end. Before leaving, Davidson approaches the bench to retrieve some paperwork.
Thank you, George.
You're welcome.
Can I have a handshake?
That's okay,
Yeah,
ma'am.
okay.
Yeah.
Thank you.
I appreciate the sentiment, but
I
we don't
appreciate
do that.
you.
Okay.
Both petitions were dismissed, and the case is now closed.
Want to know why the judge originally said you had to be drug tested? Is because the only thing that you're fired up about in life is your marijuana.
We head to Gaylord, Michigan for a probation violation hearing. 31-year-old Dawn Crow has pled guilty to retail fraud. A year earlier, Crow was arrested for shoplifting an item from a sex shop. She pled guilty and was sentenced to 6 months probation with several conditions, including that she complete volunteer services through a county work camp, attend a retail fraud class, and undergo regular drug testing. But when she failed to comply with those conditions, she was ordered back to court. Today, she appears remotely before Judge Kevin Hesselink to find out if her probation will be revoked and if she'll be sent to jail. Also at the hearing is Crow's probation officer, Natasha Hill.
Allegation made against you is that you were non-compliant with your probation. How do you want to resolve this matter?
I would like to extend my probation just because I did move downstate. I do have a job, so I'm trying to pay everything off. The reason why I have not been able to test is because it's $45 every time I test, and I owe the testing facilities almost $120. I'm not made of money. I do not have the money to test. But why am I being drug tested when there's no substance issue with my case whatsoever?
What kind of a store did you go into to steal from?
It was a sex shop, and I stole fuzzy handcuffs.
Says the Fantasies Smoke Shop.
It was a sex store, Your Honor. The smoke shop is a porn store.
I wasn't the one who sentenced you. So all I can tell you is the judge did put it in place, and you've not been doing it.
Your Honor, I admit I smoke marijuana for my autism.
So what doctor prescribed marijuana for autism?
It's not prescribed, it's recreational. It's the only thing that helps.
How do you know that?
When I take 2 hits, I can finally feel normal.
Now you can feel stoned is what you can feel.
Your Honor, it's not like that. It's recreational for me.
Do you understand what recreational means?
It's because I don't have a medical card. That's why it's recreational.
I've never heard of marijuana being used for autism.
It's $275 to go get a medical card. I don't have that kind of money.
Stop smoking marijuana, you'd have money to do your drug testing.
I'm not going to stop smoking. I'm sorry. Not going to happen.
Your
I
Honor,
have dropped-
with her attitude in court, I'd be willing to change my recommendation to 10 days jail and discharge her.
Why? I don't have an attitude. I'm down here working. I have a job. I have to go to work tomorrow.
You don't have
I
an
can't lose
attitude?
my job.
Oh, man. Want to know why the judge originally, on my view, said you had to be drug tested? Is because the only thing that you're fired up about in life is your marijuana.
No, it's not, Your Honor. That is a bull-faced lie.
Judge Hesselink appears to have run out of patience and tries to wrap things up.
So, Ms. Crow, do you want to do all of your probation requirements, or do you want to do 10 days in jail and be done?
I will do all my probation requirements. I'm not going to jail.
I'm going to adjourn today's hearing for 3 months. You must do everything, or we're going to have a problem. You understand?
Yes, sir.
All right. Talk to you in 3 months.
Thank you.
3 months later, after Crow failed to complete any of her probation requirements, the judge sentenced her to 10 days in jail.
I just want to go home.
No, you don't want to just go home. You want to continue to argue and to argue and to argue and to argue and to argue.
We head to Siren, Wisconsin for a bond hearing. 49-year-old Lee Moritz has been charged with violating a no-contact order and intimidating a victim. A year earlier, Moritz's ex-wife was granted a 4-year no-contact order against him, claiming domestic abuse. But 9 months later, police say Moritz violated the order when he texted his ex multiple times. Then 3 months after that, he made contact again and was ordered to appear in court. Today, Moritz appears without an attorney before Judge Malicia Mogan to hear if he'll be released on bond. The state is represented by Assistant District Attorney Jose Villard.
Mr. Morris, did you receive a copy of that new complaint, and that's what it looks like in your hand?
Yes.
Did you read it?
I didn't read the whole thing.
But do you understand that charge and that maximum penalty?
I really don't.
Okay, well, it's easy. They're alleging on June 13th, 2025, you violated that. You broke the law. You had contact. Don't say a word. Okay, and it's alleging that you knew you had contact and you knew you weren't supposed to have contact with that domestic abuse injunction, okay?
I spoke to Jose and he didn't help me at all. I had a lot.
Not supposed to. He's state. He's on the opposite side.
Oh, I don't know how this works.
Okay.
I have no idea how this works.
He's the attorney that prosecutes you, so he's not the guy who can help you.
Oh.
If you're
see,
looking-
I don't understand how any of this works.
What you would probably like to do is retain your own attorney or apply for a court-appointed attorney.
I don't have enough money to buy an attorney right now.
Okay, so at this time, you're representing yourself, and that's fine, and you can do that. Not guilty plea is going to be entered on your behalf. Mr. Villa, what is an offer that can be presented?
Your Honor, at this time, I cannot present an offer. We have further cases that are coming down the pipeline.
Okay, so you can understand, Mr. Moritz, there are more allegations of you doing the very same thing, and it looks like more charges, more cases are coming down the pike, okay?
It's all Greek to me. But I need to talk to her because she did all my business work, all my taxes, and I need some documents from her to get.
Can't.
I didn't abuse anybody. I've never abused
Here's the
anybody
thing,
in my life.
but there is, in effect, a domestic abuse injunction that says absolutely zero contact. You can have zero third-party contact unless it's through an attorney. So that's your option.
But I need some paperwork from her.
And I told you how to
need
do
it. I don't have any money, so my life's in your hands, Your Honor.
It's not in my hands.
I'm at your mercy. So
I'm not going to argue with you.
I don't want to argue,
Then
Judge.
stop.
What if she contacts me, though? I'm not allowed to contact.
Ignore it. Sounds like it's, you know, kind of lopsided. Why can she contact you and you can't contact her?
That's what I don't understand.
That's the law.
There's not justice.
Okay.
It's all false allegations.
Okay. Again,
I just want to go home.
no, you don't want to just go home. You want to continue to argue and to argue and to argue and to argue and to argue. So stop.
Moritz was released on a $500 bond and ordered to appear again in 2 months. He's also been charged with one additional count of violating the no-contact order. He's pled not guilty, and all 3 of his cases are pending.
It's not a waste of time. It's my job.
Your motion is denied. I really hope you can work it out.
Can't. Not even
No.
old person. You want, sir? Come here.
We go to Louisville, Kentucky for a hearing. 24-year-old Nicholas Erkey owes $1,690 in back rent. 10 months earlier, Erkey signed a lease with his 62-year-old grandmother, Margaret Owens. But she claims Erkey moved out without paying his full rent, so Owens filed a complaint. And the court ruled in her favor, issuing a garnishment to help her collect the unpaid debt. Today, Owens and Erkey both appear without attorneys before Judge Tanisha Ann Hickerson because Erkey has filed a motion for the second time to appeal the garnishment.
This is on for Mr. Erkey's motion. I understand. Are you challenging a garnishment?
Yes, ma'am.
On what basis?
Within the financial issues, highly struggling.
Okay. I do not disagree that you have some financial hardships and lots of debt. Let me ask, are you willing to work out a different payment plan with him?
Your Honor, this is an ongoing thing that he's trying to get out of not paying the garnishment because he had the money when he was working and when he lived with me, I told him
Stop doing that while she's arguing. That's rude.
I don't agree with
I
that,
don't
Your
care.
Honor.
It's rude. Don't do it. And don't yell. Are you willing to make any other payment arrangement with him? That's all I'm asking.
No.
Judge Hickerson then gives him another chance to speak.
Direct everything to me. Remain calm, cool, and collective for me. The only reason you're here today now is to challenge the garnishment because you feel that it is a hardship to you.
Yes, ma'am. And I did appeal.
And what happened on appeal?
They never notified me of anything.
I can tell you today, it was affirmed. It's in my phone.
When I went
It's
in,
affirmed. It's affirmed. Let's move on.
I'm only able to pay $100 a month if I have to get her off my behind.
It's not gonna be good enough for her. Sorry.
I can't do any more than that. That's it.
Mr. Erkey, get another job.
Good luck with that. Look. Sir.
No, first of
Your
all,
Honor.
sir.
A deputy approaches Erkey.
Too much. You're too
Your Honor.
much. You're too
I'm
much.
so sorry.
I know I don't need to hear anything else. Your motion is denied.
Is there any way that I can
Garnishment to
reappeal or
garnishment to remain in effect. I really hope you can work it out.
Not even with old person. You know what? Sir, I'm fine. Please. There you go.
After his outburst, Erkey throws his papers to the floor and heads for the exit.
Sir, I'm fine. Please.
As these members of the gallery try to block out the noise, additional deputies arrive on the scene. But Erkey seemingly continues to resist.
Give your hands. Stop resisting. Leave me alone. Don't calm down. Get your arm up, man.
After several minutes, and with the help of multiple deputies, Erkey is taken into custody. He was charged with disorderly conduct, resisting arrest, and criminal mischief. Erkey remained in custody for 12 days before being released on bond. He's yet to enter a plea, and both of his cases are pending.
I'm trying to keep some sort of decorum in the courtroom. Now you're rolling your eyes.
I'm not rolling my eyes, I'm looking at my daughter.
You rolled your eyes.
We're in Detroit, Michigan for a hearing. 30-year-old Asia Outerbridge has been charged with having an open container of alcohol in a vehicle. 6 months earlier, Outerbridge was a passenger in a car when it was pulled over by police. She was issued a citation and ordered to appear in court. Today, Outerbridge appears remotely without an attorney before Judge Sean Perkins to discuss next steps in the case. Things get off to a bumpy start.
Why are you so late?
Because I have a paper right here that shows my court started at 1 o'clock. Right here, if you can look.
It looks like I saw 9 a.m.
Well, I had 1 o'clock on one of those papers.
You just showed me a paper, Miss Outerbridge.
Yes, I did. Right. So when I called.
No, we can't talk at the same time.
Well, I apologize for being late. Excuse me.
Stop.
You asked me a question. I'm just trying to answer it.
Put whatever you're trying to prepare down.
I'm trying to see my daughter.
Outerbridge finds herself in a jam when she's caught making her child a peanut butter and jelly sandwich during her court hearing. Judge Perkins is not pleased with that or the defendant's choice of attire.
Get your coat, you gotta put your properly dressed on. I am
properly dressed. I have on a t-shirt. I am properly dressed.
Is that a robe?
It's the problem, sir. I'm not even doing it. You asked me a question, I'm answering. My daughter is sick. I had to keep her home from school. I'm just trying to feed her. That is it.
Ms. Outerbridge, I'm sorry that your daughter is sick. But again, you're in court, okay? And we're gonna treat it as such.
I'm properly dressed.
No, don't talk.
I have on clothes. I have on clothes. I have on clothes.
Bye, Miss Outerbridge.
I have on clothes.
Judge Perkins ends the hearing. Later that day, he recalls the case.
City of Detroit versus Asia Outerbridge.
But this time, Outerbridge appears with an attorney. After she's sworn back in, the judge picks up where he left off.
When I'm talking, this is my courtroom. You don't talk. And I'll give you a chance to speak if I need to know something from you, like I asked you that. And now you want to get upset with me because I'm trying to keep some sort of decorum in the courtroom. Now you're rolling your eyes.
I'm not rolling my eyes. I'm looking at my daughter.
You rolled your eyes.
I'm looking at my daughter. Okay. Okay.
There it goes.
Okay.
Go again. I'm the one that can dismiss this case or not. Come back in the screen, ma'am. Don't go rolling your eyes and under the screen now.
Sir, I think you're being very biased because I'm quiet. I explained why I was in my robe and I explained why I was late to the court. You are still nitpicking. I'm not trying to argue with you. I have a 3-year-old jumping around over here. I'm just trying to pay attention. That is all. I'm not rolling my eyes at you. I don't have an attitude at you. If we're going to be biased towards the case, because you're upset with me about being late, then maybe I should get in the bridge.
Trial date, July 1st, 2025 at 9 a.m. Best of luck to you, Ms. Outerbridge.
I can go?
You may.
A month later, Outerbridge appeared at her trial, along with the officer who issued her the open container citation. But when the officer informed the prosecutor that he had no recollection of the incident, nor did he have any supporting notes or video footage, a common occurrence in similar cases, the case was dismissed.